deal a minute to say a couple of things about some progressive and the construction. I'm stepping down as a partner at the progressive here. Long plan and I'm very excited about. But at the same time, we've brought in, I think many of you in the room know Helen, who joined the team as a partner earlier this year. Alicia and I worked together for, we don't like to admit, but over 25 years, we've been doing time. But also the team is in such fine people. I know you sort of say this, we've got such a strong team of groups and we're great lawyers and teams and additionally from the coaching side of things, we've got Shanti Fraser, who most of you will never know, who is sort of, if you're anything construction lawyers, she's busy one day on Australian night, still existing, sort of doing projects and doing good issues. So I just wanted to sort of mention that after many years of construction lawyer, I'm looking down at a partner role, sitting down top role. But yeah, that's my minute. I don't know if it's more than a minute, but I just thought I'd say welcome to half the group. Just great to see the people start to store. You know, but we get the truck. It's going to be a while before the commercial project comes. The real change of the front stage. Especially in infrastructure sector, we're seeing a lot more projects coming through. And I think it's really great that it's generally for everybody we're part of it. But I think after a few years, we've been tough. I think put out here at the beginning of the period. Somebody told me the 2,000 personal year to get to improve the life of 3 years. And what the number is, total people in the whole construction. Yeah, it's sort of that's the deal with part of it. I'm going to hand over to Helen, and Helen's going to go and stuff.
Well, thank you very much for that, Michael. And let me just say thank you to Simply Wisdom for hosting this event and providing my screen to help us spread it across the country. And, you know, the SCR is always really grateful to its member law firm for the assistance they give us in that regard. So thanks, Mike, and thanks, Simply Wisdom. And welcome everybody. It's great to be back after something of an absence, and particularly on a really fascinating topic tonight. But we just welcome everyone, members who are joining for the first time, guests, and everyone coming along. I'd like to do a special welcome to those joining us at Helen at our meeting hub, being hosted by Emma Burke, and also those who are joining us online from Wellington, who for darling couldn't get their live performance due to flight cancellation thanks to the truly horrendous weather that has been inflicted on significant parts of New Zealand over the last week. And welcome to everyone joining us online as well. I think we've got something like 150 that's been registered, so there is a great deal of interest in this topic. Before we get going, just a couple of SCL notices. First of all, we have Donald Gardner from asking us about parametric insurance, which is quite an interesting subject, particularly in these days of climate change and climate disaster. So the date is Hawkins, the 25th of November, so Steve diarised that. It's also been doubled as our interview function. Now the other thing that we had to do is that on 27th of November, 5:30, we're going to be holding special general meeting to vote on new constitution that we need to register in order to be compliant with the company corporate. There will be more information circulated to you about that in advance of the special general meeting. Okay, so now to this evening. We're talking about the likely adoption in New Zealand of proportionate liability instead of joint and several liability, and the changes that that is going to make. We're privileged to have Adjunct Professor Helen here, who headed up the initiative really to get this moving. And as part of the consultancy team retained by Indy to advise on the reform. So thanks for coming across to Australia, from Australia, I should say, share Lovegrove. And Kim, I think, is going to be presenting on what is it? Rewriting the rules. Proportionate liability in New Zealand construction law and demystification of the responsibility-based structure. Kevin's going to be joined by Colthart, who will begin with proportionate liability in practice. So I think neither of these gentlemen are actually strangers to you. Both have presented before. Kim Lovegrove is a New Zealand barrister and an international law reformer. With more than 3 decades of experience in practice and policy development. He is chair of the International Building Quality Centre. Mark, of course, is a senior barrister and arbitrator with over 30 years experience in construction, property and commercial disputes. And he has acted in numerous multi-party disputes in the construction field and is appointed arbitrator and adjudicator. In more than 75 proceedings, either arbitration proceedings under construction contract act. He is recognised in Worldwide as a leading construction barrister. So please, everyone, welcome me in joining our presenters. We're going to save questions to the end to avoid disruption and assist finishing on time. For those of us who are joining us online, feel free to shoot questions that will be held in abeyance to be asked at the end. Thank you very much.
Thank you, Helen. Lovely seeing you again. And yes, thanks Society of Construction Lawyers and Simpson Grierson for hosting this. Melanie, you've done a wonderful job in terms of dealing with logistics. The flight actually wasn't cancelled, Helen. We were circumventing Wellington for 2.5 hours. And then we had to fly back. So the poor devils in Wellington were in the invidious position of being notified literally 45 minutes before the seminar that it was going to be a no-show by Mark and I, but we can't control the weather. 2 years ago, I was here addressing the conference with Mark for SCL, and we were talking philosophically about the difference between proportionate liability and joint several liability. Well, proportionate liability is going to be real. It's a done deal. Parliamentary Council is currently drafting the wording to introduce proportionate liability. So it's not going to be a discussion about, you know, the virtues of joint several liability vis-a-vis proportionate liability, because that's rear view mirror stuff. It's imminent. It'll be the first half of the next few months, I imagine, promulgation. And what I suggest you do is fixate on how it's going to look in a profoundly different paradigm. Okay. Minister Pink will go down in history as being the minister that had the courage and the resolve and the vision to introduce proportionate liability. And I have immense respect for advocates of joint several liability. There's very learned people who've got very articulate views. I happen to be an advocate of proportionate liability, but I'd no way trivialize an advocate of joint and several liability, because the fact of the matter is it's been around a long time. It's been a document that served many jurisdictions well for many, many decades. But the minister had the resolve to facilitate its introduction. And as he said in the media release that accompanied cabinet sanction, under the new model, each party will only be responsible for the share of the work they carried out, period. And that announcement marks probably the most consequential liability reform in New Zealand's building law landscape. Generation would be probably parsimonious in terms of use of language, I'd suggest ever. For the first time, the entrenched doctrine of joint several liability will be displaced in building disputes and replaced with proportionate liability. So, definition in plain English. Under JSL, where multi-defendants are at fault, a plaintiff may recover the entire loss from any one of them, regardless of the actual responsibility. That defendant must then seek contribution from others. In practice, solvent defendants, especially counsels and insured professionals, shouldered residual loss. So proportionate liability for local government should be a come to Jesus moment. And if I was local government, I'd be handstanding over the place in an absolute state of euphoria, because for the first time ever, their insurers are just going to be underwriting their liability. And for people who've got a penchant for wine or alcohol, it's like you won't have to pay, you won't have to shout drinks for everybody all the time, every time, just your own. Which is a bit like Australia, because that's the land of it's your shout, mate. Generosity is a little bit deceptive there, because it's actually not a gift for beer. There's a condition there implied to you reciprocate the shout. So it's a bit like that. Now, under proportionate liability, each party bears its loss strictly in proportion to its fault. 10% responsibility equals 10% liability. 50% equals 50, period. Consequences profound. Counsels and insured defendants will no longer be treated as insurers of last resort. It's an old, well-worn cliche that a lot of plaintiffs have had a love affair with, the insurers of last resort, but that will no longer be the position. They will remain suable, of course, but only for their corralled share of responsibility, not any overweight risk created by insolvent or primary actors that were responsible for defects. My role in law reform when I was young buck in my mid-30s, I was afforded the great honor and privilege of heading up a team that generated National Model Building Act. And it was basically a law reform blueprint that culminated in the reconfiguration and recalibration of building control mid-90s onwards. And two of the reforms it introduced were proportionate liability, compulsory insurance, actually the third one, 10-year liability capping. In a state like Victoria, the 10 years starts to run from when the building official issues an occupancy permit. Here, it's from the last act, error, or omission of the last actor on the building site, whenever that was, 10 years hence. And some experienced litigators will know how tricky that is. That sort of litigation doesn't exist in jurisdictions like Victoria. When the project's finished, the occupancy permit's issued, 10 years starts to run. And if you occupy without an occupancy permit, you commit a statutory offence, you can be prosecuted for illegal occupation. So 99.9% of homes and buildings have OCs there. Whereas here, I think 30% of buildings don't have a triple C. So I'm delighted that I've been afforded the honour to be involved in generating its inauguration in Australia, and then in the dusk of my life involved in assisting the government with like reforms here. Now, Australia's two-phase journey. In the early 90s, Victoria introduced proportionate liability and mandated PI insurance for all key practitioners, builders, engineers, architects, designers, quantity surveyors, building inspectors, and private services. These guys do 80% of building permit delivery in Australia. Councils are largely out of building approval. So unlike the private certification system that collapsed here in about 2008, that did not occur in either Japan or Australia, and it will be a permanent part of the building permit delivery paradigm. New South Wales introduced proportionate liability in the early 90s, but only mandated insurance for residential builders and certifiers, not the whole 9 yards. Other jurisdictions adopted proportionate liability too, but not all of them complemented it with the holistic insurance ecology. Phase 2, turn of the century, insurance hardening. HIH, a major insurer that underwrote a lot of building practitioners in Australia and auditors, accountants and the like, collapsed. Global PI markets tightened and cover availability became more challenging and expensive. Governments extended proportionate liability right across the Australian economy to preserve insurance sustainability. And they had regard to the fact that it had been very successful within the curtilage of the Building Act in Victoria. It approved resilient, sustainable, and that was basically a case study that had succeeded, that encouraged the 9 governments and the respective AGs in that country. The Law Reform Commissions there, like the Law Reform Commission here, did not like proportionate liability, advised against its introduction. The governments were not persuaded with respect to that point of view. So in short, the 1990 reforms were driven by utilitarian risk allocation in the building sector, and the 2000 expansion driven by insurance sustainability, because they did not want to lose key insurers from the marketplace. New Zealand context different. New Zealand didn't experience a HIH style collapse, but JSL produced similar distortions. Councils became in defendants of last resort, build and develop insolvencies left councils and insured professionals to bear the residual loss. Plaintiffs targeted the remaining solvent defences, so councils and insured defendants became de facto insurers of the system. Regulators turned guarantors, you could say. Now, New Zealand context. In an article written by Roger Partridge, I just adapted my slide last couple of days because this was in the Law News. In fact, I've got a piece for the Law News within a couple of weeks coming out. He said the practical effects of legal indeterminacy quickly materialised with leaky buildings scandal. Councils became the last man standing when the builders disappeared. You can read the rest of it. But interesting comment, I thought. Parliament never decided councils should insure homeowners against building defects. Now, I love fiddling around with Chat 5 and infographics. And what I love about it is you can generate original bespoke work that is narrative friendly. So here's this poor devil, you know, council building surveyor, there's a little badge on there. And the problem with when you use infographics, the first person comes up as something like a supermodel, and I might be a supermodel male one, and or a female one, and sometimes the clothing is really a bit risque. Needless to say, this guy's not wearing risque clothing. So I said, give me a guy that's middle-aged, carrying a bit of weight, probably played rugby, broad shoulders, and struggling under the weight of a defunct building. And there's the poor old council struggling under the weight of the building. So that'll be yesteryear. One party, often territorial authorities, can be left carrying the full burden when others can't pay. In terms of carrying the can, I was addressing the fire engineering conference a couple of weeks ago, and I had the carrying can metaphor, and I got Chat to devise a big can with a grim-looking council building surveyor and an insured engineer looking very grim. And in the can, there was a delighted-looking property developer and with a smug on his face, and he had a pair of white plaid shoes. And you may say, well, what the hell have white plaid shoes got to do with property developers? And I do have a reason. Years ago, I knew a property developer, and he had 50 pairs of white plaid shoes. And I said, why the hell do you need 50 pairs of white plaid shoes? And he said, well, in case one of them gets dirty, I just chuck it in the bin and I've got 49 more. So it wasn't entirely metaphorical. So New Zealand context continued. Councils, as you know, if you're in a council here, became insurers of last resort. And for many years, that was the status quo. But in today's inflationary and risk-sensitive environment, the considered view, and obviously the government was persuaded it's not sustainable as a doctorate. So it's my submission that the decision rebalances the system, recalibrates tort liability and ascribes liability to those responsible to avoid overweight risk migration to local government. Now, there's philosophical issues here. At its core, the reform is philosophical. Joint and several liability enshrines and canonizes plaintiff primacy. Guaranteed recovery, well, not guaranteed. You can't always implicate a council. You know, where 30% of the buildings don't have triple Cs. Well, you're not going to be able to get the council for negligently issued a triple C. So that needs a slight qualifier that didn't provide a guarantee. But in the majority of circumstances, recovery was distorted and deep pockets were targeted and council was a viable target. Proportionate liability enshrines responsibility. Liability tracks contribution, creates fairness and coherence. And fairness is a subjective term, but I'm using it, I suppose, in a mathematical sense, ultra logic. And this is, why should one party pay for the sins and omissions of another party, period? That to me is fundamentally unfair. But I'm not trivializing the fact that the plaintiff isn't entitled to a degree of fairness too, but it's all relative to the concept of fairness. Proportionate liability is utilitarian and majoritarian. Now, when I'm talking about utilitarianism, I'm talking about John Stuart Mill, and I'm talking about Bentham, and I'm talking greatest happiness for the greatest number, which is really consistent with democracy. The majority votes get the government in, and majoritarian, of course, it's the majority. Recognise the interests of the citizens and the ratepayers whose funds have long underwritten misallocated risks. Interesting philosophical divide. I'm fascinated the difference between Murphy and Hamlin. Not totally on point, but Hamlin, until the defect was discovered, it was so obvious that any reasonable house owner would have called in an expert to make the investigations that properly carried out would have revealed that the local authorities' breach of jury. Now, the reason reflected New Zealand's reliance on public inspection systems rather than any greater sentimental attachment to home ownership. What I find fascinating, that judgment, it says there's a cultural difference. New Zealanders love their homes. But as I said the other day, it was the English who invented the term, a man's house is his castle. Now that's a pretty dramatic illustration of how the English love their homes. We don't have any castles here. So I was fascinated that there was a view formed that the English homeowner was less enamored of their homes than New Zealanders. It intrigued me. But I suppose the conclusion is an English homeowner would agree that the home is paramount, but not that council should bear the loss, a distinction that defines Murphy's individual responsibility ethos. Proportionate liability now reconciles those philosophies, aligning liability with contribution while recognising the broader public interest. The other thing is, I've always been fascinated by the fact that joint several liability has been perceived as being consumer protection. Depends how you define consumer. You can define the consumer as the claimant, and I'd suggest that's too narrow a lens, as it does not tell the whole semantic story. I'm submitting that the three constituents that share the system: plaintiffs, citizens and ratepayers and providers, even builders, architects, engineers, certifiers and insurers, they're consumers in the sense that part of the fact they need the system to work well. They're consumers of a system. So I'm suggesting there's three different types of consumers, suggesting true consumer protection embraces all three. And JSL favoured one, PL restores equilibrium for the majority, or doesn't restore it, introduces it. Couple of insurance myths and realities. Now, I'm on record as being a huge advocate of compulsory insurance. Huge advocate. I pushed heavily for it in Victoria, and because I was involved from gestation to completion, I was involved in persuading the government that insurance should be mandatory. This is a very different country. I'm amazed that lawyers don't have to, you're not required as a lawyer to carry PI here. Yet I've never met a lawyer who doesn't carry PI. But in Australia, you don't carry PI, you can't get a practicing certificate. You have a law degree and a qualification, you call yourself a lawyer and you don't have PI cover, you'll be prosecuted. And I make this point because just because I'm very attracted to compulsory PI doesn't mean to say the system fails if there isn't compulsory PI. It would be misleading if I was a perpetrator of that misnomer. New South Wales in the 90s required only residential builders and certifiers to be insured. They did not require all of these actors in Victoria. They probably realized that 99.9% of architects, engineers, and building surveyors carried insurance anyway. So that was the market reality. So the lesson is compulsory coverage strengthens the system, but proportionate liability can operate without it where professional insurance culture is strong. Having said that, I reiterate, I'm a very strong advocate of mandated insurance and am well known to be so. But I reiterate the point, New South Wales is a case study that verifies that the system was sustainable without compulsory cover. Few case law anchors. I've mentioned Murphy, Hamlin. Now, what I think is the gold standard in terms of a proportionate liability case in operation is Turner Mara, Victoria Proprietary Limited versus Owners Corporation number 1, often called the Lacrosse case. Docklands Fire. The fire engineer was held liable for 39%, building surveyor 33%, architect 25%, and the guy that lit the cigarette that ignited, that set fire to the curtain, that ignited the aluminium combustible cladding, and then the fire snaked the way up the building. That party was held 3% responsible. Now, what I like about this as a gold standard is insured, insured, insured. Plaintiff got virtually every dime back. These guys, beautiful position. We're indemnified. We're not going to lose our home. We're insured, like lawyers. We get if a lawyer gets sued, thank God for insurance. We don't have to put our house on the line. Hunt and Hunt versus Mitchell Morgan nominees, High Court authority, and it's got a very good illustration of how liability will be apportioned. And typically, of course, Australian cases won't be binding on New Zealand, but I'd suggest to you that they'll be highly persuasive. And when the final wording comes out, have regard to the given jurisdiction in Australia that might have similar wording. Because remember, there's 9 countries in Australia, federal government, state and territory government, all have the different building acts. There's 9 different suites of proportionate liability provisions, and they're not identical. So it's generated different case law, different interpretation, and you lucky Kiwis, you have the beautiful benefit of having seen this car driven for 30 years, road tested, and all the defects in the machine have been identified, and you can basically benefit from having a high octane car at your disposal. And I think Parliamentary Council is going to have regard to some of the better wording in Australian template provisions. So hypothetical, if you've got a builder, a structural engineer, a council, they're all found liable, 40%, 30%, 30%. If that guy didn't have insurance, or through some freak of nature, this lady didn't have PI under GSL, 100%. Under proportionate liability, different arrangement. Now, a couple of questions for Parliamentary Council. Some questions. Will proportionate liability extend to claims under the Fair Trading Act 1986, misleading and deceptive conduct? In Australia, there is equivalent legislation. It's federal legislation, and it has its own proportionate liability provisions for misleading, deceptive conduct. How will it interact with the Law Reform Act and contribution between tortfeasors? Will it apply to duties under the Building Act 2004? I'm assuming that the Building Act will be the instrument that promulgates proportionate liability. It certainly was the case in Australia in the 90s. It was the Building Acts. But then when there was wholesale amendment, it was the Wrongs Acts that repealed and made redundant the Building Act proportionate liability provisions, and they were consumed by broad church application legislation that controls auditors, accountants, proportionate liability per se. So New Zealand draft should mirror court-tested Australian legislative narrative wording to avoid uncertainty, I suggest. Now, this is my understanding of the legislative process and timetable. I'm not retained by the government since Cabinet sanctioned the provisions, so I don't know what the insurance ecology is going to look like, and I can't say categorically what the wording is going to look like because I'm not involved in that. But drafting is on foot now. Now, I'm also chairman of the International Building Quality Centre that has a collage of preeminent international board members, one of whom is Dame Judith Hackett, who presided over the Grenfell inquiry. A friend of mine is a senior economist at the World Bank, etc. But we're currently finishing the first ever International Model Building Act, and we've got a proportionate liability provision in it. And a couple of friends of mine who are senior jurists in Victoria very kindly looked at that proportionate liability wording, and they were tasked with, okay, if you're interpreting that wording, Your Honours, what are you going to find? Intended doesn't necessarily always culminate in that which is delivered. So we have honed some template wording that I've given to my friend Dr. Michael Warren, who I work closely with an MB, and they have passed this model wording that's had high-level judge input for them to consider in the drafting instructions for Parliamentary Council in New Zealand. Sharon Birchall, Helen, you remember the Venerable Sharon? She was involved in that interrogation of the wording. So I hope it's persuasive. Now, so transitional provision will decide whether it applies to cases already filed. I doubt it, but there can be retrospective legislation. It's very rare. It's not popular. So I would surmise that the day it's promulgated, any new case that's filed post-promulgation will come within the curtilage of the new regime. So monitor the implementation, critical path closely, filing timing may determine whether JSL or PL governs the case. Now I've mentioned that, but just have a look at that as reinforcement. So it would be my hope that Parliamentary Council will have regard to it. I've already said the New Zealand Law Commission was never enamoured of proportionate liability, but things have changed, insurance markets have changed, the New Zealand Law Reform Commissions were more or less in lockstep with the Australian Law Reform Commissions, but then the governments decided, pursuant to their democratically elected mandates, all 9 of them, that they'd go with proportionate liability. And I think that's because the insurance markets are volatile and they're trying to look at greater sustainability. So current reform is not reactionary, it's evolutionary, it's evidence-based adjustment to modern risk realities. Broader implications for practice. It'll reshape practice, litigation strategy, contract drafting, insurance markets, reduce local government exposure. And the real question is no longer why proportionate liability, but how quickly we embed it into contracts, policies, and dispute resolution processes. Now, on point, 3 Australian jurisdictions allow one to contract out of proportionate liability. So some punters will forum shop. They'll issue proceedings in a jurisdiction that allow them to contract out. Personally, I find contracting out of statute repugnant because my view is the statute is the paramount instrument. Don't undermine the integrity of the statute by allowing parties to contract out. That's my personal view. So 3 Australian jurisdictions allow contracting out. Another jurisdiction exempts fraud from its application. So one of the High Court decisions where there was a fraudulent actor that was implicated to the tune of 65%, in that particular jurisdiction, that High Court authority would not apply. Another jurisdiction in Australia exempts customers. So hopefully, and also the Tesseract decision has found that proportionate liability applies to arbitration. The 2 dissenting judges say this doesn't make sense. Arbitration can only be between 2 parties, the parties that execute the contract, the principal and the builder, or the builder and the subby. So to have this mechanism whereby one party can say, well, the builder, I'm only 40% liable, without having the opportunity to consolidate or join other implicated parties, architects, engineer, is intriguing. So that's why when we drafted the wording, the Model Building Act, for the consideration Parliamentary Council here, and Sharon Birchall was very insistent on that, specifically state that it will not apply to arbitration, because it's not designed as a contract for arbitration. But that'll be a matter for the Parliamentary Council. So preparing for transition, post-promulgation, need to audit the files, get new instructions for potential apportionment issues. Insurers will update their risk models. I think it will require far more front-end due diligence by plaintiffs in determining who's particularly culpable. Daryl, you were saying to me, typically building surveyors that are contracted with council have not been sued. There will be a profound paradigm shift in that. They will all of a sudden have an attraction traditionally that they did not have to plaintiffs and or defendants. It's probably not something, I know notice you're not smiling, and you probably don't have any reason to smile about that. For councils, it reduces existential exposure. Homeowners, I'd suggest they be particularly diligent. If the government doesn't make insurance mandatory and you're acting for a homeowner or a property developer, you'd be, as part of your due diligence, saying, okay, only deal with insured parties. For ratepayers, it means public funds no longer subsidise another's insolvency. So, there's a judge. I always like to have DIA in my optics, you know, multicultural, multiracial, multi-age, men, women. I haven't seen a bald man, there he is. So that even a bald man like me gets a gig. So, as the Minister says, it's time to put responsibility where it belongs, hence it's called the responsibility-based doctrine. Insurers, I'm repeating myself here now, but just have a quick glance at that, digest it. that it does indeed mark a watershed moment in New Zealand's legal history. Okay, that's my talk. Now, my dear friend, the highly venerated Mark Colthart, he's a delightful man and a wonderful traveling companion. I said to him yesterday, I just said, you are the most civilized person. I'm not used to meeting such civilized, incredibly well-mannered people in my travels. And I mean that, I'm not being metaphorical. It intrigues me what a civilized man you are. So there we go, Mark.
All right. Well, clearly I've spent the last couple of days pulling the wool over Kim's eyes about how polite and well-mannered I am. But we have had a little bit of fun, including a slightly terrifying plane ride down to Wellington, as you heard about. So my talk, what I've wanted to do is try and put what is coming in the way of proportionate liability in building cases into some sort of practical framework, so we can start to begin to get our minds around how things will be different under this new regime. And being a litigator, I thought I would focus on how do we plead these claims in court. The tricky part of my presentation is that, as we all know, we don't know what the legislation is actually going to say. We don't know even which act it is going to be in. As I agree with Kim that there is some logical sense that it might be folded into the Building Act. So the task and the real trick for me is to try and use a crystal ball and imagine what might this actually look like in practice. So when we look at the Australian regime, as Kim says again, there's 9 different versions of the law in Australia. And I've tried to focus on really what are the key concepts that come out in that jurisdiction. And to my mind, there are really four key concepts that that will likely arrive in our legislation. The first thing is that the legislation must define what an apportionable claim is, and that's the first thing. The second thing is it must define what a concurrent wrongdoer is. So in what situations are you going to have a court dealing with a case and imposing proportionate liability? So that's the second. The third thing is it's going to have to say that in those cases, a judge must apportion the claim. So there's no sort of wriggle room. If the case is one which is an apportionable case, judge must do that. And the fourth key concept will be that a defendant's liability must be limited to their responsibility. So that's the broad framework that I have thought about when I've been putting this together. Now, will this work? No, that's going the wrong way. Here we go. So I've decided to also do a hypothetical case. I found that photograph on the internet and immediately the title came to me, "The Front Fell Off." Now, that title may ring a bell to some of you. And so what I thought, for a bit of light relief, I'll use 2 of my 15 minutes to play you a video clip about a defective construction case that involved, it's a maritime one. It involved a severely defective ship. It involved a discussion about building materials, and regulation of building materials is very relevant in the current context. It involved human resources and health and safety, crucial in our industry. And it involved a discussion of the environment, which is always topical. Most of all, it involves the late, great John Clark, famous Kiwi comedian who you might recall as Fred Dagg, but also had a very rich career in Australia as a comedian. So
Senator Collins, thanks for coming in.
It's a great pleasure, thank you.
This ship that was involved in the incident off Western Australia this week.
Yeah, the one the front fell off?
Yeah.
Yeah, that's not very typical. I'd like to make that point.
Well, how is it untypical?
Well, there are a lot of these ships going around the world all the time, and very seldom does anything like this happen. I just don't want people thinking that tankers aren't safe.
Was this tanker safe?
Well, I was thinking more about the other ones.
The ones that are safe?
Yeah, the ones the front doesn't fall off.
Well, if this wasn't safe, why did it have 80,000 tonnes of oil on it?
Well, I'm not saying it wasn't safe. It's just perhaps not quite as safe as some of the other ones.
Why?
Well, some of them are built so the front doesn't fall off at all.
Well, wasn't this built so the front wouldn't fall off?
Well, obviously not.
How do you know?
Well, because the front fell off and 20,000 tonnes of crude oil spilled into the Seacourt fire. It's a bit of a giveaway. I just like to make the point that that is not normal.
Well, what sort of standards are these oil tankers built to?
Oh, very rigorous maritime engineering standards.
What sort of thing?
Well, the front's not supposed to fall off for a start.
And what other things?
Well, there are regulations governing the materials that they can be made of.
What materials?
Well, cardboard's out.
And?
No cardboard derivatives.
Like paper?
No paper. No string. No sellotape.
Rubber?
No, rubber's out. They've got to have a steering wheel. There's a minimum crew requirement.
What's the minimum crew?
Oh, one, I suppose.
So the allegations that they're just designed to carry as much oil as possible, the hell with the
ludicrous.
consequences, I mean, that's ludicrous. isn't it?
Absolutely ludicrous. These are very, very strong vessels.
So what happened in this case?
Well, the front fell off in this case, by all means, but it's very unusual.
But Senator Collins, why did the front fall off?
Well, a wave hit it.
A wave hit it?
A wave hit the ship.
Is that unusual?
Oh, yeah. At sea, chance in a million.
So what do you do to protect the environment in
Well,
cases like this?
the ship was towed outside the environment.
Into another environment?
No. It's been towed beyond the environment. It's
Yes,
not
but
in the
into
environment.
No, but from one environment to another environment.
No, it's beyond the environment. It's not in an environment. It
Well,
has
it
been
must be
towed
somewhere.
beyond the environment.
Well, what's out there?
Nothing's out there.
Well, there must be something out
There
there.
is nothing out there. All there is sea and birds and fish
And
20,000 tonnes of crude oil
what else?
and a fire
And anything else?
and the part of the ship that the front fell off. But there's nothing else out there.
Senator Collins, thanks for
It's a
joining
complete void.
us. Yeah, we're out of
The
time.
environment's perfectly safe. We're out of time.
Yeah.
Can you book me a cab?
But didn't you come in a Commonwealth car?
Yes, I did.
What happened?
No, the front fell off.
Good on John Clark. Well, I hope you don't mind 2 minutes of a bit of levity on a Thursday evening, as opposed to hearing me drone on. So, turning to my hypothetical situation, thinking of the picture that I put up before, imagine a typical civil claim in the High Court relating to alleged defective building work where the front fell off. The plaintiff is the building owner, and there are multiple defendants before the court. The first defendant, shouldn't say third party there, I put in, because I'm feeling generous, the first defendant will be the council, as sometimes it is. Second defendant would be the designer, third the builder, fourth the poor old subby, maybe the bricklayer in this case, who put the front on the house. So that's our scenario. Now, as we all know, under our current regime, what we have here is that the plaintiff claims against each defendant and the relief claimed is the same. That is judgment against each defendant for the total loss or damage. The defendants scurry around each cross-claim against each other seeking contributions, or alternatively or additionally, they join in other potentially liable parties also seeking an indemnity or contribution. Now, if the plaintiff succeeds, there's judgment against each party for 100% of the loss those parties have caused, but with the rider that they would each be entitled to a contribution from the other liable defendants and third parties. Now, the kicker, as we all know, is that if the liable parties are unable to collect on their contribution claims, they end up paying the entire judgment. So that's the problem that councils and other insured parties have been facing for a long time here. What happens under proportionate liability in that same scenario? Well, the first point I put on there that I have been wondering about is that there should be an increased motivation by the plaintiff to join all potentially liable parties. That makes logical sense to me, that if you're a plaintiff bringing this type of claim, it would make sense to be proactive. Identify the potentially liable parties, join them in at the beginning, and take some control of that process. What I am told is that that doesn't happen in Australia. That plaintiffs in Australia typically join one defendant and they leave the joiner of additional liable parties and defendants to the defendants. And I guess that might be because they think, well, that's a cost that the other defendant should have to bear. We'll be insulated if they ultimately fail to succeed against those defendants against costs. So that first line, I'm not sure whether that will play out at all. What will play out is the second line. The defendants have this obligation to identify any other allegedly liable parties. And that is because other than parties that are not before the court because they're insolvent or they're dead, the only parties that the court can allocate the loss to are the parties before the court. So if you're a defendant and you're wanting to share the loss, you have the onus to join the other allegedly liable parties. The third point is that the defendants will have to plead this limitation on their liability as an affirmative defence. And in the last part of my presentation, I will take you through what I think a typical pleading might look like. That might be of some help to the litigators in the room. And the judge in the judgment must apportion the liability between the wrongdoers. And the key part, this third part of what I was talking about before, the liability of each party is limited to the amount reflecting the proportion of the loss that the court considers just and equitable, fair, having regard to the extent of the third party or defendant's responsibility, I would say, or culpability for the loss or damage. And that's going to be the tricky part for the judges, to work out who's the most culpable party, who's the second most, who's the third most, who's the fourth most, and allocate percentages against those parties. And I think logically, to me, that is a logical process for doing that, and I imagine that's what the court will do. So in the previous case that we're talking about, in this case, as in Kim's slides, a typical kind of divvying up of the responsibility might look like that. We know from oodles of case law that counsel is likely in most standard cases to be landed with about 20%. Of course, they'll argue otherwise, and in some cases it'll be less, in some cases more. That's established quite firmly. Designer, builder, subcontractor, in my example, will be allocated those percentages. The key difference, as Kim has pointed out, if the builder is insolvent, if the subcontractor is gone and can't be found, it's relocated back overseas, the counsel and the architectural designer, assuming the designer is insured, will not have to pick up the tab, the 60% that the builder and the subcontractor would otherwise have to pick up. To put that into a context of how it might be pled in court, the key point, I think, is that defendants will have to plead this as an affirmative defence. There are 4 steps that they will need to plead, and they align closely to the framework that I discussed at the beginning of my talk. So the first thing I suggest that will need to be pleaded will be jurisdiction. So you'll need to plead that this is an apportionable claim. And in New Zealand, we're starting off, and maybe we're finishing, but we're starting off only with claims in relation to defective building work. So I suggest that the definition will be relevant to that. So that's the first step in the pleading. The second step is you must then plead that the other people who are in court with you, the other defendants, they are concurrent wrongdoers. And so what that means is that their acts and omissions, either independently of you or concurrently with you, caused or contributed to the loss that is the subject of the claim. So that's the concurrent wrongdoer component. The third component is to plead this limitation of their liability, to say that if there is any liability, that must be limited to an amount reflecting the proportional loss claimed that the court considers just and equitable, having regard to the extent of its responsibility for the loss. So that'll give us a bit of a guide. It might be useful if this legislation turns out how I think it will turn out. The fourth and interesting part of the pleading, I have taken this from a real case in Victoria, and I've adjusted the wording accordingly, is that in Victoria, as an alternative, in case a judge decides this is not an apportionable claim, they plead what we would plead in New Zealand, that the defendant is entitled to an indemnity or contribution from the others in respect of any sum the plaintiff may recover. So that will reflect very closely our current practice in New Zealand. And it would be wise to do that as an alternative. One of the features of litigation like this in Australia is sometimes plaintiffs will go out of their way to frame their claim in such a way as that it's not an apportionable claim. So they'll frame their claim as a strict liability claim for breach of warranty, for example. And so defendants will need to insulate themselves against the risk that a court might be persuaded it doesn't fall into this regime. So that's about as best as I can do with my crystal ball at the moment. We'll have to wait and see what exactly the shape of the legislation is. But
Would you
hopefully
be able
that
to
gives
take
us a
some
bit of a
photos
guide about how it might work
Now,
in this hypothetical
if it
world
goes
that we'll
out,
be facing next
it
year
comes simply
in all accounts. Thank
four
you.
zeros, 000. Then no quadruple zero, 4 zeros.
Right.
And
Questions?
that's the camera.
Might need to get Kim to come back for this part.
And we've got a couple of mics around too, so we'll drag those out. People, Helen, would you like to grab them on? When the questions come through, if you don't mind phrasing it so we can hear it online, if you don't mind.
Yeah, sure.
Okay. It's in a sense, I guess it's really two questions. The first question is, Victoria requires compulsory insurance, right? Including for builders. And I guess my question there is, typically when you're talking about PI for builders, you're still talking about just design responsibility, etc. for builders. Is the experience in Victoria that the cover provided for builders is broader than what would be normally PI in New Zealand?
Okay, I'm glad you asked that question. Why I asked that question? Because there has been some confusion about builder cover in Australia. Firstly, residential builders are required to carry what's called home warranty cover. Home warranty cover is not a PI product. Now, there is confusion in the marketplace here between the difference between PI and residential building cover. They are entirely different products, categorically. And I know there are others that have a different view. Very happy for them and all power to them. But the way the residential home warranty cover operates is there's $300,000 worth of cover for every residential builder. It's illegal to carry out any building work at all if you're a residential builder unless you've got the home warranty cover. And that covers defects, completion costs, and some legals. And for 2 years, the product generates per se defects cover. For the subsequent 4, it's structural. And that is not universal in Australia. New South Wales has a similar product, whereas the engineers, the architects, the building surveyors, the quantity surveyors, and building inspectors, they carry conventional professional indemnity cover. I'm not saying builders aren't professional, but the PI cover is for that class.
Right. And so for builders, it's only going to be if they actually do any design for any reason.
Well, no, building. It's for defective building work. The design would be the designer, or the other thing is designers and architects are required to carry PI cover. So the design negligence will be visited upon the architect or the engineer or the designer. The warranty cover covers defective building work.
But it's not PI cover. Builders don't have PI cover.
No way.
Okay.
Unless I suppose you've got a design and construct builder in the commercial milieu that's got the fusion, that hamburger with the lot where there's design and construct, and they'll often have engineers and some of them will carry PI cover.
Okay, the second question was how does it work being able to contract out of this sort of legislation? Because effectively, you're contracting out not just on behalf of yourself and the contracting parties, but all the third parties who aren't a party to your contract, who are supposedly, are supposed to be able to get the benefit of it. So, like councils, for example, how does contracting out work?
Theoretically, you can do it by warranty, by indemnity, or I suppose a deed, but I have not come across one case where it's been adjudicated upon. So it's pretty cryptic area. That's why I'm very, very much against it.
It's going to be a head scratcher, that one, for all of us.
And
so.
hopefully New Zealand will not import a contracting out mechanism, because as I say, it pretty much undermines the purpose of the legislation.
Yeah.
Thank you.
Good questions. Thank you for that, Helen.
I've got a couple more insurance-related questions, 2 of them. One, given that a building defects claim would typically run easily $10, $20, $30 million remediation costs, do you have a feel for what levels of cover, you talked about builders having $300,000 of cover, but what level of cover architects, structural engineers and the like might have? And secondly, you mentioned the need for building, residential owners to do their due diligence on insurance. Is there some sort of register of insurance cover or any way for a purchaser who's not contracting with the builder, architect, etc., to check cover?
It'll be an academic question if New Zealand decides to make insurance compulsory. Then the due diligence requirement will not be as dramatic. In Victoria, consumers got a pretty relaxed view. They just check to see that the engineer and or the architect and or the residential builder is registered. Fascinating, in New Zealand, you've got your LBP scheme where it's the likes of roof tilers, carpenters that are registered LBPs, and people say, oh, no, builders are registered. No, they're not. Carpenters are not builders. Builders subcontract to carpenters. So what's fascinating about the New Zealand LBP scheme at the moment is it's what in Australia would be called the subbies. The subbies are required to be registered by law as LBPs, whereas the engineers, the architects, and the builders are not required to be registered by law as LBPs, whereas it's total inverse situation in Australia. The architects, builders, and engineers and certifiers are required to be registered. Now, when you say typically 10 to 20 to $30 million costs, that's quite a broad band. I mean, our law firm there's been practicing construction law for many, many years, and I wouldn't say it's the typical profile of a building dispute. I'd say in terms of quantum, the typical profile is probably $500,000 to 2 mil, maybe 3. That's what you call vanilla or garden variety. But in most jurisdictions in Australia, the building practitioners they are required by law under Insurance Gazette to carry $5 million worth of PI cover. And to do with higher liabilities, well, if there's inadequate cover, they won't be covered. It's just like a lawyer here. If a lawyer gets sued and he hasn't taken top-up cover, he's only got the minimum. Well, there isn't actually a minimum. Correct me if I'm wrong, because you're not required by law to be insured as a lawyer here. But we carry top-up cover because we do some big work. And the first thing I did when I got readmitted as a barrister here, and I'm delighted, and you made an announcement today, I'm a member of this gentleman's chambers, 48 chambers, so delighted to join your fold. First thing I did, of course, was get PI cover. Didn't have to though. If I call myself a barrister in Australia without carrying PI cover, I'd be, well, no, capital punishment's gone, but metaphorically, I'd be shot. But the view is culturally, New Zealand doesn't like to have mandated things. Apparently it's a cultural nuance, which I suppose is quaint and nice. But being a regulator, historically, it's not really my cup of tea.
You had various percentages up there on proportionate. How's that determined, and who determines those percentages?
The judge and the expert witnesses. They'll go into battle. Whoever's for the architect would be trying to impugn the engineer or the council or whatever. That's a matter for the judge. The persuasiveness of your skilled construction lawyers, and I emphasize skilled construction lawyers because operating under this regime does require skill. And I've read a couple of articles that have been published, and I've thought, that's totally wrong. I've read other articles and I thought, that's totally wrong. And it's so dangerous for New Zealand lawyers to speculate on Australia because they're talking about 9 countries. So you can't say the Australian way. You've got to pick it. Is it Victoria? Is it Northern Territory? So back to your question, the percentages will be dictated by the judge having heard from the skilled construction lawyers and their venerable expert witnesses And by and large, the judges get it right. In terms of lacrosse, there was an appeal and the percentage allocation to the fire engineer was lifted because we're dealing with ACPs. So on appeal, there was a minor adjustment of about 2%.
Thanks, Kim and Mark. I've been having a bit of involvement with MB during this process and providing a bit of advice on behalf of NZIBS as building surveyor. They recently approached us and asked what our thoughts were on making PI mandatory for building surveyors, architects and engineers. And our response really was, and it was similar to our response at the round table back in April when we presented with MB, was, well, you may be trying to fix a problem that actually doesn't exist, because currently in New Zealand, you know, if you belong to an organisation like NZIBS, RICS or Engineering New Zealand, you're required to have a PI anyway as part of that membership. So really our response to it was that mandatory in terms of making everybody have it may be a step too far, but perhaps it's requiring those individuals to have a membership of some sort and an affiliation that then required you to have the insurance. So a bit of a default setting more than anything.
I don't think mandatory is a step too far. I just think it's a very brief step, because you correctly identify that the overwhelming majority of professionals carry it. So this scaremongering, oh, unless it's mandatory, the world's going to fall. It's not accurate. But I'll say it again. I'm all about mandatory cover. I'm all about mandatory cover. But the system still works without it for the reasons you said. I remember at that meeting, it was a bit of a polite little setup question, but I just said, we've got chief executives from various associations here and you're one of them. I said, what percentage of your members carry cover? 100%. Architects, 100%. Engineers, 100%. And I thought, yeah, gotcha. So because everybody said, oh, shock horror, you know, there's got to be no market for insurance. Well, actually there is. And it's been there for a long time. And it's not novel to New Zealand. It's universally available PI for any number of professions. So the critical thing is, this is what Mark and I are trying to do. We're trying to get rid of some of the myths, the misconceptions, the misinformation, and bring clarity to the table. So thanks for that question, Daryl.
Sorry, I was just going to say that I think one of the issues with mandatory PI, and I don't think it really is an issue, but I think conceptually the issue with requiring it is that it does require that there be insurers who are willing to provide PI to the, you know, the sector, if you like, in question. And insurers' willingness is not necessarily to be taken for granted, depending on market conditions. Now,
well, they've been willing for quite a while, because as you said, don't have an issue getting insurance.
Yeah.
I mean, heaven forbid.
No, I agree, but I think conceptually that's the issue. As a practical matter, you're probably right that generally there is no.
From a practical matter, you're correct, and there have been insurance failures. When God, about 20 years ago, 50% of my practice was doing insurer defendant work, and the major insurer went under, and that caused that 2000 crisis. So there is precedent for insurers going under. The other thing is, in the 90s in Australia, at the time of Camelot, if you retired, 10-year cover would be triggered upon retirement or cessation of practice. That Camelot cover, that utopian cover, existed until the turn of the century, when the insurers said, we cannot any longer underwrite 10-year runoff cover because the risk assumption is too massive. So you're right to say it's no guarantee, but from a practical point of view, the insurance markets are usually robust.
I want to add to that as well, that some of the major supporters of proportionate liability reform have been the major insurance companies, because of course they don't want to be wearing 100% of the liability of their people who are not their own clients paying premiums to them. So when the Law Commission looked at this back in 2014, if you have a look at the submissions, there's an excellent submission, for example, from IAG saying, we want this, and this will enable us to underwrite more risks because we'll have far more certainty as to what we are underwriting. And we will be prepared to consider entering into markets that we're not currently in because we'll have far more certainty. And that makes logical sense to me. And that's come from the largest insurer from their own submissions.
We'll just hear from Donald about insurance.
So just two points there. The PI requirements for most membership organisations, those limits are extremely low, and they won't really go far in the event of a claim. So you know, look at what level of cover you need rather than the minimum you're required to have.
Totally.
And the other point to the mandatory insurance, the insurers would prefer it to be mandatory because that way there would be more take up. So there's a bigger premium pool so that they can have a more or a better chance of making money. If it's totally voluntary and the claims start building up, the premium dries up and the cover goes away. Whereas it's mandatory, they still can collect some premium and have a better chance of offering a product that is affordable by having the bulk premium pools available.
You've actually brought up a very important point. As you say, because there's no minimum required, whereas under the mandatory regimes and the like of Victoria, there is a minimum and it's in an insurance gazette that's promulgated by the government. And in the case of, if my memory serves me correctly, currently for practitioners, it's not less than 5 million. But without a mandatory scenario here, you might have, I don't know, 500,000.
I think it might even only be 200,000 for some organisations, which is ridiculously low.
That's problematic. And that is really problematic. And so, you know, you've got venerated lawyers here who will be engaged by clients to say, well, what should we do about insurance? And they'll say, well, see the broker, but by God, you want to ensure that the amount of PI cover you've got is going to be commensurate with the risk. And that's, look, beautiful work for the lawyers, lots of good work here for lawyers. It's sort of, you know, economy's stagnating, but might be a lawyer-led recovery.
Let's hope.
We're universally loved by all.
Mike, I've got a question for you, Kim, and you might not know the answer to it. So if you don't, I've got a backup question. In Australia, where you talked about these the states moving to proportionate liability, did you see any changes to premiums for professionals? I guess what you're talking about, or what you've just talked about with the answers to the last couple of questions, were there'd be more appetite for insurers, but for those of us that are operating as professionals, architects, engineers, etc., should we expect to see reductions in our policy premiums, or will they just stay the same?
Logic would suggest that you should, yes, because you're not underwriting strangers. I mean, insurers for local government must be going cockeyed about this. Yeah. I mean, really, they're no longer exposed to third, fourth parties. But that'll be a matter for the market to decide. In terms of, was there any adjustment to premiums? I don't know. What I do know is practitioners that have a bad claims profile end up paying very, very high premiums. And some of them got to the point where they could no longer afford to pay the premium because of their recidivism. And so because they couldn't get insurance, they couldn't practice anymore.
Okay, so I'll have a quick crack at the second question as well then, if you don't mind.
Of course not.
I think, Mark, you were saying that the proportionate liability only applies to building work. In the past, I think I'm correct in saying claims that I've been involved where there's an expert advisor, that we've seen real estate agents and pre-purchase inspectors and the like all part of claims for defective buildings. Will that, what you said, I guess under the proportionate liability if I interpreted what you said correctly, those guys won't be able to be part of the same claim. Will
Pre-purchase possibly.
Yeah, I imagine that there will be a relatively wide definition of what would be captured. What I was contemplating when I was writing that part was what the Building Act currently says in relation to the 10-year long stop, that it's talking about claims relating to building work. And so there's a beginning of a working definition already in the Act. And part of the job of the parliamentary drafting people will be to get that definition exactly right.
Okay.
So,
yeah, I was thinking about that
crystal
definition.
ball. That's a good question. Yeah.
There's a couple of questions online. Yes, so Minister Pink said the switch to PL will be accompanied by consumer protection measures to protect plaintiffs who face a shortfall in recovery. Having experience in Australian jurisdictions, what consumer protection measures do you consider appropriate and best suited for the New Zealand context?
Look, I'm not going to preempt the mind of government, and by virtue of the fact that I was engaged by government, I'm not going to speculate. All I'll say is what exists in Australia in terms of what I consider to be in places like Victoria robust insurance ecology is mandatory cover for key actors, frontline troops, as it were. And I'm attracted to the residential warranty scheme. It's been there a long time. It's got a long history. In fact, before the residential warranty scheme for builders was mandatory, there was a thing called the Housing Guarantee Fund. I'm showing my age here, and it used to provide $40,000 worth of warranty that was state-backed, but that was eclipsed in the late 90s. But the safeguards are more robust in some Australian jurisdictions than they are here, and in some Australian jurisdictions they're very weak.
I think also relevant to that question is our own experience in New Zealand over the last 25 years. If you cast back 25 years ago, it wasn't common for a purchaser in the residential context to go and get a building report before they bought a building. And so in those early leaky building cases, when the argument was run that the homeowner had been not looked after their own interests by not getting a building report, the courts were sympathetic. And that stopped. It stopped in somewhere in between 2000 and 2010, where the court started saying, no, look, purchasers have an obligation to look after their own interests. You need to get a building report. And so then what we've seen is that folded into the agreement for sale and purchase in massive bold capital letters saying you must get a building report. And so the market has, in a sense, reacted in a way to try and help increase consumer protection in a kind of more organic way. And that's now very well embedded to the extent that people just, unless they're foolish, don't go out and buy certain types of buildings, particularly without heeding the warning in that agreement for sale and purchase. So I think that's also a vital component. Under this new scheme, people will need to be more aware of their potential exposure and aware that they might not be able, won't be able to just fall back on the parties that they've been used to.
I'm just going to get my phone.
Sorry, this one's probably for Mark.
Lucky for you, I'm still here.
You don't have my phone.
It's on the point of demonstrating why the front fence fell off.
Yes.
Assuming it's not the plaintiff that has to demonstrate why it fell off, they're just saying it fell off. And it would be the defendants arguing why that fell off in order to limit their exposure for the proportional.
I think in a sense, in most cases, that would be correct. But there will also be plaintiffs who will be very motivated to allocate the loss to certain defendants, particularly solvent insured defendants. So the plaintiffs will have a real argument to run about who they say is liable, and they'll need expert advice about that to run those claims. And then you're correct in the other sense that, as we currently see with contribution claims, it's a battle between the defendants, each pointing their finger at the other with the support of their experts, to let the judge arrive in a position where they can allocate the loss according to culpability under this new system. So both of those things will be in play, I think.
And in terms of boots on the ground, what we typically do when we initiate legal proceedings, when there's multi-parties that are going to be implicated, if we're acting for a plaintiff, we'll issue probably against the builder and then wait for the builder to join the building surveyor and or the architect and or the engineer, so that you're not having to fund multi actions as a plaintiff. Having said that, you keep an eye on, within a few months, whether or not the defendants have actually joined third parties and pleaded proportionate liability. So you've got to keep an eye on that. In most instances, they do so very quickly, but it's prudent to muscle up with the expert witnesses right from the get-go to get an idea of what level of culpability given parties are, and just keep an eye on who's joining who and who's not. And so we might amend pleadings 9 months in to generate to attack another defendant if that defendant has not been implicated by joinders by either by the defendants.
After the proportionate liability percentage is determined, won't contractual liability caps come into play to reallocate the liability potentially back to the plaintiff, i.e. the designer's cap is lower than their proportionate liability percentage?
That's very novel thinking. I'm not experienced with that. I haven't come across a situation where that's occurred.
It would potentially apply, of course, where you have litigation between contracting parties. If we're talking about tort liability between contractual strangers, then that's not an issue, obviously. So yeah, that will be something I predict will be argued hard. Yeah. Mm.
I just wonder if we'd be having this debate liability if New Zealand hadn't gone quite a long way away from the tort law in terms of building defects, and the liability of councils is one, but in terms of the recovery for pure economic loss, and also policy decisions of councils. And I mean the departure from Anne's Merton Borough, whatever that is, the old UK case law, where we've gone so far away from that we've ended up with a situation where we've got councils footing the bill. And I don't know, I've been away for ages, but I mean, it does seem to me that some of this is of the making of our courts and the way that we've departed from.
Interesting you say that, because that gentleman I quoted, that was the theme of his article, that the courts have really waded into the regime of government policy. So what you say is tenable. Interestingly, Canada and America, a number of the jurisdictions have adopted hybrid forms of proportionate liability. But yeah, if a British approach had been applied, where you can't sue councils for economic loss, then
you can't sue councils for policy decision, like in terms of a policy to inspect at a certain time and budgetary reasons and that kind of thing, and pure economic loss isn't recoverable against any defendant. So it's sort of it's a very different system that we have here that I think has led to some of these issues that we've seen and that we're trying to grapple with now.
Oh, one other thing, personal injury is exempted from the operation of all of the proportionate liability provisions in Australia, just like it's not capped by the 10-year cap. Important that I mention that.
Yeah.
We'll just have Mark do the thank you and wrap up.
I can do that. Kim, Mark, thank you very much. Very insightful in our little exploration into proportionate liability. It'll be interesting to see what comes out in the next few months. So thank you very much. We do have a digital voucher for you, so you can go and put that into any store you wish. And again, look, the time and effort you've put into it, obviously we didn't get to Wellington, so well done on a huge couple of hours in the plane. We hope you had an opportunity to meet all the members here. I'm sure they've got a million more questions if you want to stay around for a little bit. Thank you to Simpson and Grierson for tonight. Thank you for the online stream and all the questions. And thank you for everyone attending. We're not the society without you, so thank you very much for coming along. Can you all join me in thanking Kim and Mark?
Thank you, Matt. Very kind. Right.